Hi, so today we're going to talk about Chapter 9, Participants in the Judicial Process. Essentially, the courtroom work group is a group of individuals who interact on a continuing basis, who share common goals, develop norms, understand how the courtroom works. It is established a network of roles that differentiate the group from others. So, because the United States court system is based on an adversarial system, we have the prosecutor on one side and the defense attorney on another. It would seem as if they would be on completely different sides. However, when you check out a courtroom work group, it's clear that they know each other on a social as well as professional basis, really because they're in the courtroom together all the time. The interesting thing to look at this document is what's on the outside versus what's on the inside. So on the outside are your defendants, victims, juries, and lay witnesses. On the inside are your judges, bailiff, clerk, court reporter, expert witness, probation officer, defense, and prosecutor. So this is suggesting that as a defendant or as a victim, when you come to the court, you are not part of that courtroom work group. You're not there all the time, so you don't have shared norms and values. We talk about the individual that is at the top. The neutral arbitrator is a judge. This individual is a senior officer in a criminal court. They're an adjudicator, a negotiator, an administrator. They will primarily ensure justice takes place. So as a neutral party, they're supposed to make sure to follow court of law and that the prosecutor and the defense attorney is doing what they're supposed to do. They will rule on matters of law if necessary. They will decide on admissibility of evidence, and they'll maintain discipline in the court. They'll look to go ahead and sentence offenders if they are found guilty. And then when a jury is not in use, when it's what we call a bench trial, then they will determine guilt. Most people think that a judge's time is spent in trial, but the majority of their time is spent in chambers negotiating procedures and dispositions between both sides, the defense attorney and the prosecutor. Typically, our judges are Caucasian, over 50. They have ties to political endeavors, often middle to upper class. 54% prior had a private practice to being a judge. And most of the time they attended law school in the state where they actually worked. Interestingly, typical qualifications: you have to be resident of the state, licensed to practice law, member of the state bar, 25 years or older, and less than 70 years. Now, the next person I'm going to talk about is the prosecutor. So some would say that this is the most powerful person in the courtroom, not the judge. So the judge is the arbitrator, the negotiator, but the prosecutor is the one that actually says if a case goes forward or not. So the attorney, whose official duty is to conduct criminal proceedings on behalf of the state or the people against persons accused of committing a criminal offense, is the prosecutor. So when something happens to you, it is no longer a case against you. It would be a case against the state, and the prosecutor would act on your behalf. Prosecutor duties would be to enforce the criminal law. They can also present evidence to grand jury, decide on what charges to file. So that's super important because we talked about police discretion. We'll talk about prosecutor discretion in a minute. But if a prosecutor decides what charges to go forward, sometimes he might just null pros and say, oh, we're not going to go forward with any charges, and then you get to go home. Right? So what they are saying, it will determine if you're going forward or if you're going to go home tonight and not have any charges, or if you're going to get locked up. So they'll direct testimony for witnesses of the state because they're acting on behalf of the state. They'll argue in favor of a conviction. They'll file appeals on behalf of the state, argue briefs before appellate, and then they will work in tandem with police, law enforcement. So prosecutorial selection, sometimes it could be appointed. All federal prosecutors are appointed. That is also appointed by the president. And then some are elected. A political figure serve a 4-year term. State and local prosecutors are elected in all but 5 jurisdictions. A prosecutor can decide, like I said, whether or not to go forward, determine the level of charge to be brought forward, determine when to stop a prosecution, or determine whether or not to plea bargain or not. And then the null pros means that the prosecutor decides to drop a case after complaint has been formally made. It could be either evidence is insufficient, reluctance of witness to testify, police error, or office policy. And what we mean by that is it could be like a blue law that even though it's on the books that you're not supposed to open up a store at noon on Sundays, the practice is people will let that happen. So if that local prosecution office says we don't care about blue laws, then they just won't prosecute. So selective prosecution is prosecutors are to charge and prosecute. They find a crime's been committed, a perpetrator can be identified, and there's sufficient evidence to support a guilty verdict. Reasons for rejecting a prosecution is insufficient evidence, due process. We talked about that with the police. So was there evidence to suggest that there was poisonous fruit? Interest of justice. So sometimes they might reject one particular case in the interest to go ahead and do a different type of case, or pick a more serious case, or allow for the case that's before them in this state to go null prosk, and then go ahead and allow for another state that, for example, I know a case coming forward where it was a sniper case. It was in D.C. and Virginia and Maryland. Well, Maryland didn't have the death penalty, nor did the District of Columbia at the time. So Virginia was the first one that said, yes, we want to prosecute them. So that meant that the district and Maryland stepped back, let Virginia go forward. Once they issued the death penalty for the sniper, they were then allowed to put him to death. So then they dropped the case for those other states. So they could also reject for, so they could potentially overcharge sometimes. So they would charge you with 5 crimes, knowing that maybe you'll plea bargain to 2. They could refer, like I said, for another prosecution. There could be a witness problem. So if it was a crime that was committed during a drug raid, that individual that was the victim, yes, were they a victim for sure, but they will not make a good witness. Improper motive of the complainant. So sometimes in custody cases, we see where individuals will bring forward a case just to try and get custody or favor of custody. Like I said, blue laws, these are laws that are happening on Sundays, but a lot of times they are no longer actually being used. Humanitarian considerations of the victim or the offender. So if the alleged offender is a paraplegic now based on the offense, or if the victim is young and they don't want to go forward, or they don't want them to have to speak in a court of law, violation of probation, parole again. So they would reject the prosecution and let the for probation, for parole, let them go ahead and violate them and send them directly back to prison. And then pretrial diversion. Sometimes when you're a first-time offender, we allow you to have a bite at the apple, which is a diversion, and so they might reject a prosecution in lieu of a pretrial diversion. So not a prosecutor, but a defense attorney. These are legal counsels for the defendant, operative or defendant in criminal cases. They represent the accused person from arrest to final appeal. They secure pretrial release. They negotiate the best charges possible. So like I said, if the prosecutor is overcharging 5, 6, 7, 8, 9, 10 charges, the defense attorney will maybe try and get it down to 5 or 4 charges. They'll defend and attempt to prevent a conviction. If a conviction is inevitable, they'll try and get the best conviction, and they'll try to arrange the best sentence possible. And then sometimes they will actually conduct the appeal. So indigent defendants come into when we talk about defense attorneys, because if you're indigent, that means that you're poor. That suggests that you don't have the money to be able to use an attorney. If that's the case, then the way that the United States is set up, we have different reasons to, once you are able to establish indigency status, then we can give you certain types of lawyers that you'll be able to see in those other slides. Different types of defense counsel. So there's private criminal attorneys, and those are your paid criminal attorneys. Those are the ones that you see online, for high power attorneys that are dealing with that they can afford, to be able to get these private defense attorneys. And then you're indigent. It could either be public defender, which is most often in the United States. It could also be assigned counsel and contract system, or even a mixed system. And the next couple slides will tell you about the different types of defense counsels. So assigned is small jurisdictions with limited resources. The judge will just say, hey, by the way, today, can you pick up this case? Contract is that law firms bid, and then public defenders, that's all they do. So like Charlotte has a public defender system. Primarily method used in the United States is the public defender system, thought of as law firms with only criminals as clients, or alleged criminals, if you will. Lawyers develop some expertise because of daily contact with the criminal law, and remember, these folks are part of the courtroom work group. They're paid for with tax dollars, and they're organized often along county or state line. And then we have organization of the courts. I'm going to skip some of these because the visuals make more sense for you to just look at them than for me to talk through them. But on the left-hand side, you see the Supreme Court of the United States, and then we have the Circuit Court of Appeals and District Court. So in federal cases, you will start at the District Court. If you don't like what's happening, you could go to Appeals, and then it might or may not get picked up by the Supreme Court of the United States. This is not always. So you can appeal a district court, but your circuit courts do not often go to the United States. So that's for federal. For your state court system, you have trial courts of limited jurisdiction. So these are municipal, county, state jurisdictions, often called municipal magistrate courts. And then you have trial courts of general jurisdiction. These are district superior circuit courts. And then you have your court of appeals, and then you have your state Supreme Court. And then from your state Supreme Court, if a case you want to appeal that, then your last ability to appeal would be to the United States Supreme Court. So these are state Supreme Courts, and then this is a Supreme Court of the United States. Again, just because you want to appeal something doesn't mean that the Supreme Court of the United States will pick up and hear your case. So there's different jurisdictions, the power or authority a court has to hear a case or decide on a particular legal motion. There's original, appellate, exclusive, and concurrent. And again, it goes into more detail in the slides that I'm not going to talk about now. We also have specialty courts that focus on a particular type of case. It can be, it could be a juvenile court, a drug court. We have veterans courts, we have gun courts, we have domestic violence courts. And so the idea is we can pull these out of regular court and have somebody that only deals with domestic violence, only deals with guns, only deals with drugs. With the idea that, particularly for drug court, we know that individuals will fail many times before they are successful in dealing with their addiction. And so they have folks that are set up in the court to know that these are more than likely going to fail at least a couple times. And so this is just another visual really looking at the different types of courts. So federal courts are established by the U.S. Constitution. Most of them federal courts are civil cases. So your jurisdiction for federal cases is if it violates a federal law, that's one. If a case occurs in more than one state, that's another reason why federal courts will have jurisdiction. If a case goes multi-state, issues dealing with citizenship, cases where plaintiffs reside in the two states, or cases where a state sues another state. So all of those will bounce to the federal court. Certiorari power, so this is where the process of a case. So a case is heard, it's set a petitioner, so that is somebody, your alleged defendant. They write a writ of certiorari, so rule of 4, and so they ask for legal briefs and oral arguments. And so what the whole idea of certiorari power means to bring the record or case from a lower court up to a higher court. So this is the idea for us to have another court look at it. There's a case conference, and the Supreme Court decides, are we going to take this case during this case conference? So not all cases that are brought to Supreme Court are actually listened. Or brought before them. And then you have the Supreme Court opinion as well as the dissent, and then you have precedent. So, as something is made, you start with the petitioner, writ of certiorari, so rule of 4 have to agree to it. Then there's legal briefs, oral arguments. They have a case conference deciding how they're going to, what's going to happen. They write an opinion and also a dissent if appropriate, and then that becomes rule of law. So the federal court, whatever happens in federal courts, will then be rule of law for state courts. So what does the Supreme Court have to hear? They have to hear when an act of Congress has been found unconstitutional, a lower federal court. They have to hear when a state Supreme Court has found a federal law unconstitutional. They have to hear when a U.S. Court of Appeals found a state law unconstitutional. And they have to hear when a constitutional challenge of a state law has been upheld by a state Supreme Court. That's the ones that they have to hear, but all of that, other than that, then they just decide based on the ones that are brought before them which ones they want to